Hello everybody and welcome back to our studies in criminal evidence. This lesson is going to move on to topic number 2 of our studies. This topic specifically is going to focus on the idea of presumptions and burdens. So we're going to look at the way in which the burden of proof operates, the distinction between legal and evidential burdens, the processes in which we can see the sort of development of the common law in relation to the legal and evidential burdens, the circumstances in which there is a splitting of the legal and evidential burdens across different parties, the ways in which we see the reversing of the burden of proof, we see the impact of human rights on these different topics as well. So there's quite a lot of things that we can get through and talk about. And so we're just going to begin by taking an introduction in this lesson to the next topic, i.e. this topic on presumptions and burdens. So really, the concept of the burden of proof is deeply baked into the process of the adversarial trial in the first place. So if you think about the adversarial trial process, it is a process in which you have sort of two opposing sides, both sort of presenting their case for why and how a particular set of circumstances have come to be, okay? And obviously, in the middle of that, you have a defendant, or at least the defendant is on one side of that particular process. And so, essentially, what this kind of system, the adversarial system, relies on is the weighing of evidence to come to a determination of the truth of one particular side. And given that that is the case, burdens are very important to show to whom certain duties are to be imposed. It also is deeply baked into the concept of the presumption of innocence, the sort of golden thread of the English criminal law, which we will get to when we look at the case of Wilmington versus the Director of Public Prosecutions. The idea here is that it is a case that there is a burden on the part of the people who are bringing the case, often the prosecution as represented by the Crown Prosecution Service. Okay, the burden is placed on them because there is a presumption at trial that the defendant is innocent until proven guilty. Okay, it is that way round rather than it is being presumed that they are guilty and it is up to the defendant to then show that they are not guilty. There are, however, different types of burden that we need to think about. The first is the idea of the legal burden. The legal burden can sometimes be called the persuasive burden, and essentially, it is the duty that rests on one particular side of the trial process to prove the case to the sufficient standard to the trier of fact. The trier of fact, of course, being a jury in an indictable case. Now, of course, you have to also remember that within this sort of scope and within this kind of thing, there is not only a burden of proof, but there is also a standard at which that needs to be shown, okay, to the sufficient standard. And the sufficient standard for criminal cases, we'll get to in a second, is obviously beyond reasonable doubt compared to on balance of probabilities, which is the civil standard. But you should really separate these things out. The burden is essentially who has the duty to do the particular thing, okay? The standard is the sort of the level to which they have to reach in order to be able to sufficiently prove that thing, okay? So think of the burden almost as like a baton, right? And the baton is given often, in the legal case, the legal burden, the persuasive burden is often the baton that's given to the prosecution, okay? But the standard is how high they have to throw the baton, if you will, okay? How high over the bar, how sufficient the fact has to be in order for there to be a conclusion as to the guilt or lack thereof of a particular defendant. I don't know how particularly useful that analogy is, but if you're struggling to understand this and you thought that analogy was particularly sufficient or quite useful, then I hope it was. Maybe someone found it useful. So the legal burden when it comes to criminal cases, of course, is something that often rests, almost exclusively rests, with that of the Crown as represented by the CPS, the Crown Prosecution Service. There are exceptions to this, which we will get to, but that's generally seen as the process that takes place. The Crown or the prosecution will have the legal burden to prove the case to the trier of fact, and like I said earlier, in an indictable case, this would be the jury, and the standard that is set for a criminal case is usually beyond reasonable doubt. Okay, so the jury has to be sufficiently satisfied that the prosecution, the Crown Prosecution Service, has shown their case, shown the guilt of the defendant beyond a reasonable doubt. When it comes to civil cases, as I mentioned, the standard is much lower. The standard is on balance of probabilities. So it's it's easier for it, let's say, to get a or at least it's a lower standard in civil cases as it is in criminal cases. And all of this is to sort of just present an idea of criminal justice in a way that sort of respects the presumption of innocence, respects the rights of a defendant, and really tries to show at least symbolically that there is a very high standard required for an individual to be found guilty of an offence. Because remember, in a lot of cases, especially in indictable cases with a jury, if you're found guilty of a criminal offence, depending on what the offence is, that can result in quite significant restriction in civil liberty. That can result in imprisonment. That can result in all kinds of things. Okay, obviously the most serious being is a life sentence. And so, really, given that that is the sort of cost of being found guilty, it should really be symbolically shown that the standard for which that cost is going to be reached is a particularly high standard, which is a good thing. It's a sort of a way of showing that the system that we are operating in is a system that operates, at least on paper and at least in theory, as a just system, a system of criminal justice. The extent to which that is actually the case in reality is, of course, one that many people will debate and argue and disagree with. Okay? So that's the legal burden. By contrast, then, we also have an evidential burden. The evidential burden is the duty that is imposed on the party to show that there is, according to Munday, quote, sufficient evidence to raise an issue. All right? Well, some have suggested, in fact, that this is less really of a burden of proof, and so to suggest that this idea of the evidential burden as being a burden of proof in a similar sense that the legal burden is a burden of proof is a bit misleading. And the famous quote that you can cite in that particular regard is the 2004 case of Sheldrake versus the Director of Public Prosecutions, where the judge in this case says that, quote, an evidential burden is not a burden of proof, it is a burden of raising. The burden of raising on the evidence in the case, an issue as to the matter in question fit for consideration by the tribunal of fact. What this means, how this relates to the idea of the legal burden, and all of these different kinds of things interrelating, the ways in which there is a sort of convergence of the legal and evidential burden, and then there are various circumstances in which these two depart from each other, is what we're going to spend the next few lessons looking at over the next few weeks.